colleagues now are ahead of me. I was supposed to sit this year again. They denied me that I had to go and seek permission from the Director of Human Resources, Alleges, that I should beg him to allow me to sit for the exams. And I told them that I would not be at his mercy.
You have not received a single salary for effectively since August last year to August this year is 1 year. August to October they were in, I think it's effectively 3 months. For 15 months, you have not been paid, your salaries. We call this press conference for two purposes. One, to highlight the very difficult circumstances in which our client, Mr. Martin Sorganero Richard Tijigbe, has been placed by the Federal Ministry of Works. And secondly as well, to show Nigerians what it means to become an active citizen, in the public space, and the attendant sufferings that come with being active. As you all know, Martins, in the common parlance, the media, you media people would describe him as a whistleblower. For us at Liberty Semper, and by extension, Public Interest Lawyers League that I lead, is a teller of truth and a witness of truth. Unfortunately, he has become the very victim of the truth-telling he indulged in 2020. The background to his circumstances is laid out in our press text. It's a lengthy press text. I don't think I'll be able to read through, since they have the facts stated out there. What I'll do is speak to these issues fundamentally, and why we think Nigerians should and must know what it takes to become a truth teller, and of course become victim of the tyranny of falsehood that we witness daily in our country. The background is very clear. Our client, Mr. Atijigbe, witnessed some of the obsequious employment practices that you can find anywhere in ministries, departments, and agencies of government of our country. It began basically in 2020. And on July 27, 2020, he wrote a petition to the then Minister of Works, Mr. Babatunde Raji Fashola, Senior Advocate of Nigeria, where he detailed out employment racketeering that was happening under the supervision of the minister. Don't forget that, as we say in government, the buck stops at the desk of the head. We are not saying that the racketeering, the employment racketeering, was organized and supervised by the Minister of Works at the time, Raji Fashola. But as the minister, he had the responsibility of efficiently supervising his ministry. Unfortunately, the racketeering took place under him. And our client wrote a petition dated 27th of July 2020 to him. In his good conscience, he set up a committee to look at the very substance of the petition written by our client. And that committee, its findings and reports have become problematic at two levels. One, those who ought to have been investigated, by the minister, became members of the committee itself, which strangely, the minister, former minister, is this very senior advocate of Nigeria, learned senior advocate. He should have known the principle of nemo judes in casasua, that no man that you complain against can become a judge or a prosecutor in his or her own case. Unfortunately, the very persons that our client alleged were involved in employment racketeering became, members of the committee. And unfortunately, our client, who at that material time, as the writer of the petition, was a hunter, the hunter for truth, became, the hunted. And two, why we say the panel was problematic, basic principles of fair hearing, were not granted to our client. Our client did not know at the time the terms and references of the committee and the ambit and remit of his past. Even where our clients made complaints around the fact that the committee hadn't followed the principles or adopted the principle of fair hearing, and that people who ought not to be members of the committee were sitting on the committee. The complaints of our client were not heeded. To. Fast forward, a report and findings were released by the committee, which our client challenged, not only at the administrative level of the ministry, but also took steps to bring the two arms of the National Assembly, the House of Representatives and the Senate, into the issue on the basis of Section 88 of the Constitution. And don't forget that the laws upon which MDAs, ministries, departments, and agencies are regulated in our country are acts of the National Assembly. So the MDAs are subject to the direct, supervision of the two arms of the National Assembly. Unfortunately, nothing concrete has emerged from the two arms. We are involved in the public petition before the House of Representatives, and several sittings have been held in respect of our petition. Unfortunately, on each occasion, it's either the ministry turns up with low-level officers to represent it, or they don't turn up. They don't turn up at all. So it's been a mouse and cat game between the Public Petitions Committee of the House of Reps and the Ministry of Works. For us, recognizing all of these issues that I've set out, we are making public demands. If you go to before that, the very substance of our claim is that the administrative panel, was compromised by its own, by its own investigation. We are making the claim that one of its members, Mrs. Mora Yoalemi, who until her retirement in 2019 was the head of the cabal and director of human resources. So employment racketeering cannot happen, without the head of human resources being involved. Even if she's not involved, our office being involved, because the human resources deals with employment, and deals with the regulation of staff activities within the ministry. So that department, human resources, cannot deny that they were not aware of the racketeering, that was happening under it. Unfortunately, the very individual that ought to have been investigated, became, a member of the committee itself. And we are saying that the State Department, where this employment racketeering thrived, our appointment to the committee was aimed at protecting herself and her cohorts in the person of Mrs. Bosede Omoni Franklin, Mr. Hamisu Hassan Ibrahim, Mr. John Umini, Mr. Koshi Ode, Mr. Richard Dokotri, etc. They all violated the fundamental principle of natural justice, Demo Judex and Kosaswa, which means that no one should be a judge in their own cause. This principle was affirmed by the Supreme Court in the now famous case of Garba Yusufu against the University of Maiduguri. It's a 1986 Supreme Court decision. This principle is foundational. It is not decorative. It is not cosmetic. Any administrative body must respect the right to fair hearing. And we are also alleging systemic violations of this right to fair hearing. Our client was not afforded the opportunity of having access to evidence presented before the administrative panel. Like I said, the hunter became the hunted. Rather than those names we mentioned being investigated, our client became the accused. He was accused of extortion and sexual harassment without any witnesses being presented and without being granted the right to cross-examine his accusers. A direct violation of even the public service rule. We're also alleging suppression of evidence. Key cases of fraudulent documentation, such as that of Engineer Kenneth Ode, who we mentioned earlier, was tactically omitted from the final report. This was a deliberate suppression of material facts, and there were manipulated findings. The ministry falsely claimed our client was transferred due to misconduct, and his official posting letter proved he was redeployed specifically for his persistence in demanding accountability. I will explain this. As we speak, while the petition was pending, our client was transferred from the office that he was at the Federal Ministry of Works to the field office, in Gwagwalada. Anybody will say that ministries, departments, and agencies have powers and responsibility to move men and materials around, but not when it concerns an individual who has raised very grave allegations against the Human Resources Directorate of the ministry. So we read his transfer to the field office as punitive. Punitive. It was punishment. And we see it day in, day out in our country. When you scream, when you shout against bad practices, as Nuhu Ribadu puts it a few years ago, that has become a popular mantra, a popular phrase, corruption will fight back. And that's what corruption did at the ministry. The real agenda for us, was not to investigate the substance of the allegations of our client, but to persecute him. For somebody who made grave complaints and allegations against the ministry, he himself became the accused. Accused of sexual harassment, which is a crime. There's even a fundamental abuse of the law here. The Supreme Court set out in Gaba against the University of Maiduguri that where offenses are criminal in nature, sexual harassment, sexual assault, is a crime, and administrative bodies cannot look into it. Cannot look into it. It's only the police and the court. Administrative bodies are not police. They are not courts. So what the administrative panel did was to assume jurisdiction over a matter that it had no jurisdiction over in the first place. And it points to the fact that a process was contrived on the basis of the allegation made by our client against the ministry, all in an attempt, to hang it. As our people say, if you want to hang a dog, just hang a bad name, on the dog, and that's what they tried to do. Another angle to the persecution that we raised, it isn't enough that he was transferred to the field office. As we speak, our client, has been constructively dismissed. I will explain. He's still within the employ of the Federal Ministry of Works. He still goes to work. but after 30 days of the month, he's not paid his salary, which invariably means that, there's constructive dismissal here, and it's part of the persecution that we raise against our clients. There are also wider issues that we are raising, threat to life. You transfer somebody from Abuja that is safe to Gwagwalada, as we know it, we all live in the FCT. We know the suburbs have become dangerous places for any person to live in and even walking. And for someone who made such grave allegations of employment racketeering, you don't need common sense to tell you that such an individual needs, the protection of the state. He has named people. He has mentioned the alleged staff, quote and unquote, who did not secure employment through the proper means. And God forbid, if these people decide to make their heart to become the workshop of the devil, they can go for our client and make his life, if not threatened, unbearable. There are also wider implications. When Mrs. Kemi Adjoshu introduced the whistleblower policy in 2016-2017, the intent was to open up the governance and transparency and accountability scope or space within the governance framework of government, to allow active citizens to blow whistle on bad things happening inside government. As EFCC or ICPC will say, will always command us, if you see something, say something. Our clerk saw things and he mentioned them. But unfortunately, rather than the state protecting him, he has become a victim of the bad things that he blew the whistle on. We make the following demands, gentlemen. We recognize the fact that David Umahi, Honorable Minister of Works, wasn't the minister at the time when this happened. But we also recognize the fact that governance and government abhor vacuum. The gains and profit, quote and unquote, liability here is what I mean, is transferred from one minister to another minister. What Fashola did not do right, it behoves of Honorable Minister David Umahi, to do right. But unfortunately, he has, because Fashola set a bad example, is following that bad example. Our client has also become a victim of the maladministration of Minister David Umahi. It has become worse. Petitions were sent to his office. He has refused to address them. Petitions have been made to the both arms of the National Assembly. It consistently ensures that the ministry is not represented at the public hearings of our petition, both in the Senate and in the House of Representatives. So it is in this light we make the following immediate and pressing demands. We are calling on the resignation of the Honorable Minister of Works, Senator David Umahi, the chairman, ICPC. I will explain. A petition was sent to ICPC. Don't forget the precinct of jurisdiction of the ICPC covers ministry, departments, and agencies. ICPC, for example, cannot investigate me, a private citizen. It's only EFCC that can do it. So petitions were activated and sent to the ICPC. Somebody who is connected to power in our country has sat on that petition, and ICPC has refused to act, which raises the question: what is the purpose of these public bodies established for the purpose of fighting corruption? When petitions written by citizens of our country cannot be entertained, cannot be looked to by the ICPC. And this petition we're talking about is not a petition that was written yesterday morning or last night. This is the petition that was submitted to the ICPC in 2020. We are talking of 5 years down the road. Down the road. Nothing has been done by the ICPC. We are also calling for the resignation of the Chairman Federal Civil Service Commission, Professor Tunji Olaokpa, and Head of the Civil Service of the Federation, Mrs. Didi Esther Walsinjak, for aiding institutional corruption and by not investigating our petitions. Our petitions are before these named individuals. Two, we call for the suspension of the Permanent Secretary, Federal Minister of Works, Engineer Adebiyi Olofunsho Olusesan, and Director of Human Resources Management, Alleges Abdullahi, for administrative malfeasance and deliberately covering up corruption perpetrated by their predecessors. These are new appointees, but the petitions are before them. The act or actions of your predecessor in office does not bind you. The law empowers you to initiate new processes, for investigative petition before individuals. We're also calling for the investigation of and subsequent disciplining of the 8-man committee members and every officer involved in the employment racketeering. We are dealing with lean financial returns to coffers of the state in our country. We know that in the past 1 year, 9 months specifically, the 2024 budget has not been effectively implemented by this government. For reasons that we know, our revenue stream, into government coffers is poor. So when governance operates on a lean budget, and you have public servants who are high up, illegally, unlawfully, criminally, employing people through the back door, and just padding up the employment register of state, what it invariably means that the expenditure of the federal government on salaries specifically, we also balloon. So what our client is doing is helping, the government to save scarce resources that we do not have. But unfortunately, it's not a citizen of power. It should be, because he's a taxpayer. You have people out there who are so powerful, who have sat on the administrative process by ensuring that nothing happens. They do not own our country. We all collectively own our country. I will continue to appeal to Nigerians of conscience out there to be involved in the struggle of this gentleman, and put on pressure on the state. And Mr. President, whose mantra is renewed hope, you can't have renewal of hope when the bad practices of the past, become the guiding principles, of today. That's why we're calling on Mr. President to take our petitions seriously, to look at our demands, that we have made. And we're also calling for the immediate nullification of the biased and unconstitutional investigative committee report, an independent investigation into the employment racketeering, particularly the cases of Ofon, Kingsley, Chibuike. We are mentioning these names because we have the facts. Engineer Kenneth Ode, and Mary Anyam Chinenye. And we are also seeking state protection for our client and for every whistleblower out there. It's become really, really problematic in our country. You have whistleblowers, when they whistleblow on bad practices, being arrested, detained, some of them, thrown into cells. We are calling on the state to protect these important citizens. They are very vital for the efficient administration and governance of our country. 7, accountability for the senior officials involved in the miscarriage of justice. 8, we also insist on institutional reforms to ensure investigative committees are genuinely independent and partial. It makes no sense when I make complaint against, for example, Arise Television. Arise Television will set up a committee, to look at my complaint, comprised of the very individuals that I'm making complaint against. It makes no sense. It's an affront on common sense, and it's an affront on justice. Justice is built on one fundamental pillar: fair hearing. You can't have fair hearing in a committee in which those you traduce, are the people sitting, on the top hierarchy of the committee. And finally, we are before the House of Representatives of the National Assembly. We also call on the House of Reps to take its responsibility under Section 88 of the Constitution very seriously. It's not enough for such constitutional body to receive petitions and allow those petitions are written against to treat the National Assembly with levity, with disrespect, with utter disregard. And that's what we have seen with the Federal Ministry of Works, particularly under Honorable Minister David Nwanze Umai. Going forward from here, some of these issues, because our hands are presently tied, we are before the Petitions Committee of the House of Representatives. If in the next 4 to 6 weeks, nothing seriously comes out of the House of Representatives, my associate in chambers have my instructions to withdraw our petitions so that we can head to the National Industrial Court. Gentlemen, I thank you for your time. And for those who came very early, my apologies. My understanding was that the meeting was fixed for 11 o'clock. The second question, because it's both legal and administrative. Like I said in the course of my presentation, it is not within our powers to question the basis for which ministries, departments, and agencies can transfer their staff around. The substance of our complaint is that you cannot transfer someone who made grave allegations against certain individuals within the ministry, high up in the ministry, allegations bordering around employment racketeering. You set up an administrative panel in which a counter allegation was made against our client, for which no evidence was presented against him, and it was not questioned by the police for sexual harassment or for extortion, both crimes. The same period that you are investigating him for the allegations that the ministry raised, and also investigating the grave allegations he made against the ministry to a feed office. You don't need a soothsayer to tell you that somebody somewhere, is fighting back because he has opened the can of worms in the ministry. That look, if we send him to the feed office, his prying eyes will not be here to look at those who are employed. It's just common sense. It's common sense. And two, the allegations he made are grave. We know how deep and entrenched employment cabals have become in our country. For somebody to beam the searchlight on the cabal, particularly on the Federal Ministry of Works. Don't forget too, in our country, there are ministries that are juicy, juicy ministries, where these obsequious practices happen, and for you to take the person out from the protective environment of the national headquarters to a field office. You are exposing this person to all sorts of elements, you know, and that's our complaint. That's our complaint about whether how many months he has been paid is here. So it's better for us to hear from the from the horse's mouth. Martins. Your pay slips, as I understand them, reflect what you receive as salaries.
Yes.
You know, isn't it?
Yes, because when I noticed I wasn't getting the alert, I
So-
wanted to find out why.
So you have not received a single salary for effectively since August last year to August this year is 1 year. August to October that we're in, I think it's effectively 3 months. For 15 months, you have not been paid, you know, your salaries, and which invariably means that you have not received any pay slips
Yes.
for.
Because I'm not suspended,
Yeah.
I'm not interdicted officially. So even my promotion exams now, 3 years consecutively now, they've denied me the opportunity to sit for those exams. My colleagues now are ahead of me. I was supposed to sit this year again, they denied me, but I had to go and seek permission from the Director of Human Resources, Alleges, that I should beg him to allow me to sit for the exams. And I told them that I would not be at his mercy, that at the right time I would be restored to my nominal position.